So we have some major developments in the battle to end the NFA's restrictions on suppressors. Now this comes after the Trump DOJ shifted its position and it actually admitted that suppressors are protected arms under the Second Amendment. But despite that shift, the DOJ is still defending the NFA and these suppressor restrictions. And now this case and issue has officially reached the Supreme Court and went to conference on Friday. A petition for writ was filed to the Supreme Court, it was granted review, and it went to conference this Friday. So we need to talk about what is now happening because there were some procedural updates and some concerns that I now have with this case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button that just tells the algorithm that you appreciate this content, and so it shares it with more people. So in this video, we're going to be talking about a case that we've been covering, which is US versus Peterson. And this is a challenge against the constitutionality of the NFA as it applies to suppressors. Now, this case has reached the Supreme Court and it has asked the court here to review the NFA's restrictions on suppressors. And this Friday, I went to conference and there's some things that have developed that we need to talk about. Now, if you're unfamiliar with this case, it really started back in 2022 in Louisiana, where federal and state law enforcement officers executed warrants at Mr. Peterson's property. And I believe he also had a home-based FFL, so they executed the warrant against those locations. Now, among the items that were recovered was a solvent trap that the government, found in his bedroom safe, and they treated that as a suppressor under the NFA because it was not registered as a suppressor. Mr. Peterson challenged that charge. He challenged the possession of that unregistered suppressor, and he moved to dismiss the charge, arguing that the NFA's suppressor registration and taxation scheme does in fact violate the Second Amendment. Now, on review, the district court rejected that argument, and this case then went to the Fifth Circuit. Now, at first, a 3-judge panel ruled that suppressors were not protected arms at all, but then something major happened. When the Trump DOJ got control of the administration, when they got control of the ATF and DOJ, they actually changed their position in this case, and they admitted that suppressors are in fact protected arms under the Second Amendment. At that time, that forced the Fifth Circuit to withdraw that original ruling, but then when it went back and issued a new ruling, it still upheld the NFA's restrictions on suppressors. They just used a different theory. The Fifth Circuit in that new ruling assumed that suppressors are protected arms, but it still upheld the NFA by saying that suppressors and that system in the NFA operates like a shall issue licensing regime. So in other words, the court treated the NFA like a permit system. And under that logic, if the government processes the paperwork objectively, according to the DOJ, and doesn't have discretion to deny applications, well, then the restrictions could still be constitutional. So the court found that even though suppressors may be protected arms, the Fifth Circuit said that the NFA survives under that Bruin theory. Now, that ruling creates some serious controversy and issues because if that logic stands, it could justify many types of firearms restrictions on protected arms simply by saying and labeling them as a shall issue licensing system. And that is exactly why this case is now heading to the Supreme Court and went to conference this Friday. Now, in his petition that Mr. Peterson and his counsel presented to the Supreme Court, they really presented two major questions that they want the court to address. First, can the NFA's taxation and registration system be treated like a licensing law? And second, does the NFA violate the Second Amendment as applied to suppressors? Now, here's where things get very interesting for this case procedurally. On March 30th, 2026, the US government filed a waiver of its right to respond to the cert petition. Now, that's not entirely, atypical. In a lot of cases, you may see the government actually waive their right to respond and simply wait until the Supreme Court actually issues an order for them to file that response. Now, typically when a case raises some serious constitutional questions, the Supreme Court will actually order them to file that response. But here in this case, the DOJ chose not to respond at all. But also here in this case, we have not seen the Supreme Court actually request a response from the government. Just 2 days after that waiver, the Supreme Court distributed this case for conference on April 17th, so this last Friday. Now, that's another key step because now the justices got together, met privately potentially, and decided what they wanted to do with this petition. But again, this all happened without the Supreme Court actually ordering a response from the DOJ. So what does this procedural posture actually tell us about this case going forward? Well, first, that waiver typically suggests that the government here does not believe that this case warrants Supreme Court review, and they're confident potentially that the Supreme Court will deny review to this case. Second, the fact that the court has distributed the case for conference, it went to conference without an additional response, potentially could raise some red flags about maybe the Supreme Court not actually going to take this case. It could also just signal that the court has no interest right now, or maybe they just wanted to send this to conference, and then, after conference on this following order list on Monday, maybe they will, relist the case, take it off, the conference dates, and just say, well, now we're actually going to order a response from the DOJ. We want you to file that response in this case after we've potentially considered it. But what we have seen in the lead up to that conference before this Friday was a bunch of amicus briefs filed by various 2A organizations advocating for the Supreme Court to take this issue serious, and they raised a lot of concerns about that ruling by the Fifth Circuit and how it really opens the door to treat a lot of firearms restrictions as the shall issue permits under Bruin, and just say, well, we can do this because we're operating as a shall issue system, some sort of shall issue permit, and therefore we can put restrictions on almost anything, magazines, rifles, handguns, whatever. Now, I will state, without that response being ordered before this conference, I don't have a ton of faith that the Peterson case will potentially survive this conference. It's going to be interesting to see what happens in the order list. The best case scenario really is that after this conference on this Monday's order list, we will see some sort of no activity really on this case at all, no denial, hopefully. And then after that, we will see a response actually be ordered by the Supreme Court. So this case is important because it warns that the Fifth Circuit's ruling has no clear limiting principle. Because if the NFA can survive simply by being labeled a licensing scheme, the same logic could potentially apply to many other types of firearms restrictions. So in other words, the federal government and maybe some states could theoretically require registration and taxation of all firearms. So that is why this case goes far beyond just suppressors and this one situation. And that's why it's one of those cases that hopefully the Supreme Court takes serious. So now all eyes will be on the order list this coming Monday or this coming week to see, hopefully the Supreme Court does not deny review to this case, and then we'll keep an eye on the docket, hopefully after that, to see that a response is actually ordered by the court. So that's where this critical suppressor challenge currently stands. The Fifth Circuit upheld the NFA. Mr. Peterson has now asked for the Supreme Court to intervene. The government waived its response, and then this case went to conference, despite the fact that the Supreme Court did not order a response from the government. So now, like I mentioned, all eyes will be on next week to see what happens with the order list, and we're crossing our fingers, and I'm sure Mr. Peterson as well is crossing his fingers, hoping that the Supreme Court does not deny review to his case, because he also has the major implications for himself of potential prison time because of this charge of possessing that solvent trap in violation of the NFA. So this is something that we're going to be watching closely. As we get more information, as we get news on what the Supreme Court decided to do, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply by liking, commenting, and subscribing. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this content, and so it shares it with more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.